This is the championship round for the 2025 Moot Court State Competition. Before we begin, I would like to thank our sponsors who make today possible. OCLRE is sponsored by the Supreme Court of Ohio, the Office of the Ohio Attorney General, and the Ohio State Bar Association, and the ACLU of Ohio Foundation. Moot Court is also made possible through the grant support of the Ohio State Bar Foundation. In a moment, I will have the judges introduce themselves, followed by the students, and then we will begin the hearing. Arguments in this championship round will last 1 hour, excluding introductions and feedback. The two teams have fought through 6 preliminary rounds, followed by a semifinal. I'm looking forward to seeing your hard work pay off. At this time, I'll hand it over to the judges to give their introductions and start us off.
Thank you. First, want to introduce ourselves. I'm Chief Justice Eric Brown. I had a judicial career, including serving as Chief Justice of the Supreme Court. I had a career at the Attorney General's office, and I spent many, many years in private practice up in the Cleveland area. But at this point, I'm here to help with all of you working as Chief Judge for this panel. Thank you.
I'm Mike Hendershot. I work for the Ohio Attorney General. I work in what's called the Office of the Solicitor General, and so my job is to do sort of what you're doing in real life.
Hi, my name is Nikki Bazinski. I am at the Wren Collective, and I got my career started at the Ohio Public Defender as an appeals and post-conviction attorney.
Hi, my name is Tiffany Carwile. I'm an attorney here at the law firm of Arnold and Clifford, and I do litigation and appellate work.
Hello, everyone. My name's Ben Tracy, and in actual life, I am an appellate attorney with the Franklin County Prosecutor's Office, and today I'm one of your associate justices.
Thank you. Now, if each of our students would introduce yourself, both teams.
Good afternoon, Your Honors. I'm Patrick Einlaw. My school code is A, my student code is A2. This is my co-counsel, Alex Matt.
Thank you.
My name is Santosh Rajan, and this is my co-counsel here, and my speaker code is N1.
Good afternoon, Your Honors. My name is Aaron Sharma, and my speaker code is N4.
You may be seated. The court will now hear arguments in the case of State of Buckeye versus Tiberius Bonaparte. Petitioner. Petitioner, you may begin your arguments.
Thank you, Your Honor.
Your Honors, before I begin, I would like to reserve 2 minutes for rebuttal time. Thank you. Your Honors, opposing counsel, may it please the court. We contend that Tiberius Bonaparte was erroneously convicted of felonious assault in that the jury incorrectly rejected Bonaparte's self-defense and transferred intent claims. According to State v. Vinson and State v. Howard, if transferred intent is to apply to self-defense, we must first prove that the defendant would have been acting in self-defense if he had correctly struck his intended victim. First, I will explain why Tiberius's actions would have constituted self-defense, and then I will argue why transferred intent should apply to Bonaparte's intent to self-defense. Your Honors, to prove self-defense, we consider 3 factors under State v. Messenger. 1, whether Bonaparte created the situation leading to the affray. 2, his bona fide belief of danger. And 3, any duty to retreat.
Why is Tiberius not guilty of negligent homicide or reckless homicide, offenses that are lesser included to what was charged?
Well, Your Honor, actually, we, the defense, do believe that if Tiberius were to have been convicted, the highest charges would be negligent assault or regular assault. However, Grange, not Bonaparte, created the situation leading to the affray, which is the first prong. Grange created the situation by kicking the rugby ball at Bonaparte, and his words and posture with the shuriken confirmed that the threat was not over. And for someone already physically compromised, it appeared that another attack was just seconds away. Under cases like Martin v. State and Palmer v. State, it's clear that an altercation begins when someone uses physical force, making them the aggressor. Here, Grange's act of kicking the rugby ball at Tiberius was the first physical aggression. Next, Your Honors, satisfying the second prong of bona fide belief, Grange, who is larger and more athletically built than Tiberius, had a deadly weapon in his hand and was asking how to throw it at Bonaparte, who was already in a defenseless position on his back in a puddle, put Bonaparte in imminent fear of death or great bodily harm.
Counsel, what do you take of the statement that he didn't know how to use the knife as he was holding it? I mean, how would he be? The students were practicing, so obviously it takes some skill to use these weapons. And Mr. Grange indicated he had no idea how to use it. So how would there be an imminent threat if he doesn't know how to use the weapon?
Thank you for bringing that up, Your Honor. Just because he may not be practiced, Tiberius knows that this is a throwing knife. That's what the weapon is intended to be. And just because Grange isn't as practiced as Tiberius and he's maybe never used it before, that doesn't deny the fact that it is a deadly weapon, which gives him that imminent fear. As to the third requirement, under Buckeye law, a person has no duty to retreat if they are in a place where they have a lawful right to be. Since Tiberius had not unlawfully entered the location, he had no obligation to retreat before defending himself. And in fact, it would most likely...
Well, as the petitioner, maybe you could direct me to the parts of the majority opinion in the appellate decision below that you think best demonstrates the error there.
Which ones, like the majority?
Whatever you want. Just, I mean, you're asking for that decision to be reversed?
Well, Your Honor, first we believe that Tiberius was acting in self-defense, and then we believe that the self-defense intent should be transferred.
I'm just wondering, what parts of the analysis that the two judges that disagreed with you below, where would you focus my attention?
Well, Your Honor, in State v. Reese, there was a criminal transferred intent, and that was something that was created in this court, and that was used in criminal cases, but this is a self-defense case, so we believe that there should be new law and new precedent set for cases like this where self-defense is the intent and someone was charged as an assailant.
What do you make of the lower court's opinion that if you extend the intention to allow for that inferred intention to go to self-defense, that it could open it up to allowing someone just to shoot through a crowd and be found not guilty?
Well, Your Honor, shooting through a crowd would be reckless behavior, and we believe that Tiberius was not acting recklessly in this situation because that was his only option, was to throw this ninja star at Grange. And if he were to have just done away with Grange and just thrown it right at Wingari, that would have been reckless. And so there would need to be, in these other cases that may open up the gates for wrongful use of the doctrine, there would need to be an analysis made for whether or not he was acting recklessly.
Well, earlier you had mentioned that you thought if the self-defense argument would not prevail, you thought negligent assault would be more appropriate. But now you're saying recklessness would all.
Well, there's both. So I said that it could be negligent assault or just regular assault, and recklessness falls under regular assault, which is a misdemeanor of the first degree, and negligent assault is a different charge, which is a misdemeanor of the third degree. So they're two different charges. Either of which, if the evidence for self-defense isn't sufficient, the court still erred in their decision of felonious assault.
Do you have a test that you would ask this court to adopt with regard to transferred intent so that it would be more limited and not allow, as the lower court said, to just open fire just for self-defense purposes?
Yes, Your Honor. Considering that this new interpretation of the doctrine would stem from this case, I suppose there could be something of similar to Tiberius, where his only choice was to throw that ninja star. That's the only thing he had to defend himself. So, applying that to other cases, we could see, did this person have other options? Tiberius didn't have the option to leave. In fact, it would most likely have been physically impossible for him to do so while lying on the ground.
If Tiberius were lying there, everything else is the same. He has only in his hand a grenade. Okay, to toss it at Grange?
Well, Your Honor...
That's all he has. The stars are back in his bedroom or something.
Your Honor, I suppose if this is the hypothetical situation, a grenade is like a gun, right? So if Tiberius had a gun, that requires less skill, and a grenade also requires less skill because you just pull the pin and throw it, correct? Is that correct?
You probably know as well as I do.
Okay, so if Tiberius were to just pull a pin and throw a grenade, I mean, that's much easier than throwing a ninja star, which he has practiced in doing.
I don't want to put words in my Associate Justice's mouth over here, but I think the reason he asked the question about the grenade is if he threw a grenade in self-defense, he would almost certainly injure or kill other people present.
Yeah.
I think the question goes to how wide a net can you spread when you, as you put it, have no other choice? What are you allowed to do? Where are the limits as far as hurting uninvolved people?
Yes, Your Honor. Thank you for the question. As the statute went on, that is established in whatever we created as, in this case, it would need to be applied to different cases. And in those different cases, those limitations would change as the criminal transfer of intent has changed over time. So would this one. There would need to be new precedent for the different cases that it applies to. The statute exists precisely for moments like this, where the law protects individuals who are in lawful places from being punished for defending themselves when fight simply isn't feasible. State v. Vinson, State v. Howard, State v. Ritchie, and State v. Reese are among the many cases that discuss transferred intent, which means that even if harm resulted to an unintended party, the intent follows the initial act.
Counsel, do any of those cases directly address whether transferred intent, whether that changes your ability to assert self-defense?
Well, they're all criminal transferred intent cases, so they differ from this one. This is a new kind of case where self-defense needs to be transferred, therefore we need to create new common law for it.
Okay, so none of them directly address it. They address it only in terms of the liability side.
Well, I suppose State v. Reese, he claimed to be acting in self-defense, but they said that his intent was criminal. So, no, Your Honor, to answer your question. In State v. Howard, the principle that malice follows the action of an aggressor further supports that Grange's initial aggression should bear further legal responsibility than it already has. If self-defense is attached to the action and he had hit Grange, then Bonaparte's actions would clearly be justified as self-defense, so that should not change if he accidentally hits Wingari. According to
I'm confused. How does Mr. Grange's intent affect Mr. Bonaparte's intent when he threw the knife and in relation to the victim that he hit? I mean, we're talking about his intent, not someone else's intent.
Yes, Your Honor, thank you. So, because Grange created the situation being Tiberius throwing the ninja star, he bears the most culpability. So, in a situation where Grange maybe didn't stand with a throwing knife cocked back, Tiberius wouldn't have had to throw the ninja star. However, that's not the case. Grange did, in fact, hold or cock back the throwing knife, forcing Tiberius to defend himself, his only choice. And because of that, if Wingari, who was the one who was assaulted in this case, or injured in this case, if she wanted to, get somebody to bear responsibility for her injury, it can't be Tiberius, because Tiberius wouldn't have had to do that if Grange wouldn't have created that situation where that's his only choice. According to State v. Reese, it is the intention, not the actual harm, that matters. The law doesn't hold people strictly liable for unintended consequences in good faith self-defense actions. Just because the outcome is unfortunate doesn't mean the action becomes criminal. Tiberius was not aiming at Wingari, nor did he act out of recklessness or disregard. He responded to a specific threat, and the result does not strip his actions of their lawful basis. If courts begin to equate self-defense misfires with assault, they ignore the very nature of what it means to act under immediate fear and threat. Just because his aim was bad in this situation does not mean he is charged with felonious assault.
Counsel, for you to prevail on the self-defense theory that you offer, do we have to extend transferred intent to something where I think you acknowledge it hasn't been done before, or is there any other path on the self-defense side of your case that we could rule for you?
Well, Your Honor, I believe there are 4 options. Tiberius faces no charges. Tiberius faces negligent assault. Tiberius faces assault. And as he already has, he faces felonious assault. And in this case, we argue that he doesn't face any of them. And what was the second half of your question, Your Honor?
Yeah, I'm just wondering, we've had a lot of discussion about transferred intent, and I think you acknowledge the case law, at least the case law you've cited to us, involves transferred intent when you're imposing criminal liability. It's not a transfer of intent for a offense. Is there any way for you to prevail as to the first of your 4 options, the no charges, without us extending the cases in that way?
Well, I think that there has to be an extension because it hasn't been done before. I don't think it's possible to cite one of those cases to protect him in this case because those are all criminal intent where they are made what their intention was after being decided by the court. In a highly fraught situation, he may not be as accurate as he otherwise is. He's at a physical disadvantage lying on the ground. The intensity of the moment and the nature of the timing of his decisions are not reasons to penalize Tiberius. It would be unjust to hold him to a standard of accuracy that not even law enforcement is held to in fast-developing, high-stress situations. The law
Counsel, do you agree that any force that Mr. Bonaparte offered would have had to have been reasonable?
Well, Your Honor, in this situation, with the facts, you're talking like with the facts we have, correct? Well, Your Honor, he only had one way to do this. He was on his back. He didn't have time to get up and physically attack him with his body. He had to use a projectile, and that's what he had in the situation.
Yeah, that's fair enough, but what I'm asking is, do you think that the law requires that someone's use of force in self-defense situations is reasonable?
Reasonable in a sense where he still has the intention of harming somebody in self-defense? Mm-hmm. Yes, Your Honor.
And how would you answer the idea that using any force against someone who does not present a threat to you is going to be disproportionate and unreasonable?
Well, I would argue that that doesn't necessarily apply to this case because he did have a bona fide belief. He was in imminent fear, and it was a proportionate counter to 2 actions that were done unto him. Grange was initially...
Except that Grange didn't end up being the recipient of the force.
Yes, Your Honor.
Wangari did.
Yes, and that's why we must protect Tiberius, because Grange started the physical aggression. He kicked the rugby ball, which was the first time that Grange hit Tiberius. Similar to a push, it was a kick that was forceful enough to knock him over. And Grange walking up to Tiberius, cocking a throwing knife back, Tiberius has a reasonable belief that he is about to be injured again. And so, in a situation where maybe, again, Grange didn't cock back that knife, then it's disproportionate, but because there were those 2 actions, it is a proportionate counter, and therefore reasonable.
Proportionate as against Franklin Grange, who was the threat.
Yes, Your Honor. And
the force didn't end up being used against Franklin Grange, did it?
No, but it was intended to.
I see.
Which is why it must be transferred to protect Tiberius.
How reasonable do you think his fear should have been, given you sort of emphasize he's practiced with this and he ended up hitting someone else. So clearly this is hard to use.
Yes.
And he sort of knows that Grange hasn't used it before. He's saying, how do I throw this?
Yep.
Why would that be a reasonable assumption that not only would he be able to throw it that distance and that he would be able to hit him specifically where he's laying?
Well, Your Honor, first, I believe we do not know the exact distance. It's a matter of a few feet, which is what we know, and that throwing knife can reach a few feet. And as you said, Tiberius is knowledgeable on this. He is very...
Do we know it's a few feet?
Well, Your Honor, he kicked a rugby ball, which I would assume and argue that is a few feet, and then he cocked back the throwing knife, and I would say, Your Honor, that it is a few feet. And then can you ask your initial question again, please, Your Honor?
Grange has never used this
Oh,
before.
yes, Your Honor.
He's asking, how do I throw this? And he might have been gearing up to throw it, but you're arguing it's actually quite difficult to have good aim.
Well, yes, Your Honor. So whether or not he's practiced and knows how to throw it, it's still a deadly weapon. It can still be used to harm Tiberius, and Tiberius knows that, and that's what gives him the bona fide belief.
Let me ask a hypothetical. Say it was a firearm
Yes.
that Mr. Grange had, and he didn't know how to use it, and the safety was on. And you could tell that the safety was on, and he was even pointing it at him. It's not going to fire if the safety's on. So would he have had a reasonable belief of imminent danger if he's a gun that the guy doesn't know how to use and won't work?
Well, Your Honor,
Point at him?
what are you in your hypothetical? Does Tiberius know that the firearm safety is on? Does Tiberius know that?
Yes.
But an arm with a weapon in it doesn't have a safety function. It's an arm, and I guess the safety
Mine's
function.
a hypothetical. I'm just asking a hypothetical so we can test the limits of the theory that you're putting out there.
Well, Your Honor, I would say that if Tiberius knew the safety was on in a gun, then he wouldn't have thrown the star. But in this situation, the only safety switch would have been inside of Grange's mind, and Tiberius can't get in there, so he cannot know truly if the safety is on, Your Honor. The law accounts for the reality that people under threat do not have time for perfect aim or ideal execution, and punishing Tiberius for a miscalculation under pressure completely undermines legal recognition. Given the legal precedents and clear application of self-defense law, Tiberius Bonaparte should not have been convicted. The evidence shows that he was the victim of an unprovoked attack, had a reasonable belief of imminent harm, and acted lawfully under Buckeye self-defense statutes. His conviction should be vacated in the interest of justice. Thank you, Your Honor.
Thank you. Respondent may go forward.
Yes, Your Honor. Your Honor, just before my time begins, I'd just like to confirm that my speaker code is N4. Chief Justice, Your Honors, opposing counsel, may it please the court. The defendant knew the risks of playing with fire. Today's case involves a teenager named Tiberius Bonaparte, obsessed with carrying sharp and dangerous weapons on his person. And one day, he injured an innocent bystander named Tina Wangari after getting into an altercation with Franklin Grange. He was later charged and convicted of felonious assault pursuant to Buckeye Code 2903.11. But the petitioner's motion to vacate his sentence lacks foundation. And Your Honors, for just 3 key reasons, the state asks you to affirm the defendant's conviction. First, this defendant acted knowingly, and therefore he is guilty of felonious assault. Now, to look at a more precise definition of what it means to act knowingly, we turn to the actual statute, Buckeye Code 2901.22b, which states that to act knowingly is when the person is aware that the person's conduct will probably cause a certain result or will probably be of a certain nature. Your Honors, before
Counsel,
this
why is it not acting with purpose when he threw the star?
Well, Your Honor, we don't intentionally believe that that the defendant actually had the right mindset to throw this shuriken at Mr. Grange intentionally, but knowingly doesn't matter what the intent is of the defendant. All we need to prove is that this defendant knew that his conduct would have a certain probable outcome. And Your Honors, this defendant was throwing these weapons into the side of a tree, and he knew that if those weapons could penetrate a tree, they could certainly penetrate human skin and cause severe physical harm to human beings. Now, when we look to
Counsel, you opened by describing Tiberius as being obsessed with carrying sharp weapons around. If I'm obsessed with carrying a firearm around, is that relevant to my criminal liability?
Well, Your Honor, we believe that the defendant's intention in this case was, in fact, to throw the shuriken because he was being embarrassed by the humiliation
I'm
he was
just wondering about the relevance of you describing his obsession with carrying these things around. Like, does that bear on what we're doing here?
Well, not necessarily, Your Honors, but however, it's important to look at a reasonable person in the defendant's shoes and how a reasonable person would act given the defendant's knowledge, circumstances, history, etc.
You saying a reasonable person after being hit with a football, knocked to the ground, and being stood over by a larger individual with a knife in their hand wouldn't act in a self-defense manner?
Well, Your Honor, we disagree with the characterization that you just presented just for one key reason, is that there's no evidence to suggest that Mr. Grange was towering over the defendant.
But that's your burden, isn't it?
Well, yes, Your Honor, but we are told that the defendant was kicked by a rugby ball into the lake, so we assume that there's increased distance between the two parties. But furthermore, if I can turn your attention to a piece of case law. In the case of State of Ohio versus Barry Robbins, the court held that even though the victim got into a physical altercation with the defendant was still able to be convicted of felonious assault, given that the victim did not present an adequate threat to the defendant's life or physical safety. Your Honors, while it's true that Mr. Grange kicked
Are there any weapons involved in Robbins?
Your Honor, in State versus Robbins, there was more so a physical altercation between the two parties, but we can still apply the logic of the altercation to today's case. Because, Your Honors, while it's true that Mr. Grange kicked a ball at the defendant, the fact of the matter is that that does not constitute imminent danger. No reasonable person in the defendant's shoes would believe that after being kicked by a rugby ball, that he was going to die in that moment.
None of us, I don't think, are saying it was the rugby ball that caused the damage, and I don't think the petitioners are saying that. They're saying it's the knife in Mr. Grange's hand that causes the threat of imminent danger. So can you focus on the knife in Mr. Grange's hand?
Yes, Your Honor. So while it's true that Mr. Grange held the kunai in his hand, that doesn't necessarily create an atmosphere where someone would believe that their life or physical safety was in danger. And if I may explain, while Mr. Grange drew his arm back, he never looked at the defendant, never targeted the defendant, and never verbally indicated that he was going to assault the defendant. Now, in the case of State of Ohio versus...
Are those first things you said, again, remembering you have the burden, are those in evidence?
Well, yes, Your Honor, but the fact of the matter is that absent the evidence that Mr. Bonaparte was the target of Mr. Grange's throw, it weighs against a claim of imminent danger because if he's not the target of this alleged throw, he can't feel that he's in imminent danger. Now, Your Honors, while it's true that...
I'm looking at the majority opinion. It says Grange looking at Ty, now prostrate in the mud as Grange again began to spin the kunai around the end of his finger.
Well, yes, Your Honor. At the specific moment that Mr. Grange held the kunai, that's not when he was actually looking at the defendant. The text that you just cited was previously from in the altercation when Mr. Grange was holding the kunai and just looking at the defendant. But in the moment that Petitioner is focusing on, when the defendant was laying on his backside in the lake, there was no reason for any reasonable person to believe that they would be in imminent danger.
Aren't these two engaged in an argument? I mean, wasn't there a trading of insults and even at least on one side, the blow from the rugby ball? I mean, how can you straight-facedly claim that two people who are clearly having an argument with each other, which has partially turned physical, I mean, what other way is there to interpret drawing back a knife at that point?
Well, sure, Your Honor. We agree that there was a heated exchange between the two parties. The state doesn't disagree with that. But in the case of State of Ohio versus Palmer, the court looked at the fact that just because a confrontation gets hostile or even heated, that does not mean that a defendant is entitled to the use of deadly or lethal force. The defendant could feel humiliated or hurt, but that doesn't mean that he's entitled to throw that ninja star. Now, going back to the intent that the defendant exhibited, the defendant observed the presence of bystanders in the general vicinity of the area, and combining that with the fact he knew of its dangerous propensity, this means that the defendant knew when he threw that weapon into a group of people, there was a high probability that somebody would get hurt.
Counsel, let's take it. So we have a group of people. that are there with Mr. Grange, correct?
Yes.
So let's say that Mr. Grange has a firearm instead of a knife in his hand, and he is pointing it at Mr. Mr. Bonaparte, and Mr. Bonaparte also has a firearm. Now, they're not 100% accurate if you don't know how to use one very well, and even if you do, you can still sometimes miss. So is he not allowed to act in self-defense because there's other people around that aren't holding a firearm?
Well, Your Honor, in that case, the distinction that you made is the type of weapon that was used. Your Honor, just because Mr. Grange was holding a knife doesn't constitute imminent danger. But
Well,
to your...
say we disagree. Say we think that a throwing knife, which is a projectile, same as a bullet, they're different obviously, but they're both a projectile. And so say we disagree that there was imminent danger, and we're going towards whether it was reasonable to act with another throwing object. How would it be different between a firearm and the throwing knife, or are you not allowed to defend yourself if there are pedestrians around?
Your Honor, it's not that we're saying you're not allowed to defend yourself with pedestrians around, but specifically, this defendant knew that Mr. Grange was surrounded by a group of people, and he threw that shuriken towards that group of people. And now his attorneys are claiming that he couldn't have acted knowingly because he didn't understand the risk that throwing that shuriken posed.
Well, I still think that answers the question. If I'm in that situation and I have a firearm and someone else has a firearm pointed at me and I feel like I'm in imminent danger, if he has a gang of people around him, you're saying I can't shoot at him and to save my own life because I might hit someone else. That doesn't seem very reasonable to me.
Well, no, Your Honor, that's not what I'm saying. In your hypothetical scenario, we would agree that there is more of a reason to believe that there's imminent danger because of the nature of firearms. They can be fired from far distances and not necessarily close proximity as we need with sharp knives or smaller tools. But Your Honors, what we're saying is that this defendant knew that if he threw a shuriken towards a group of people, he subjectively knew that there was a high probability somebody was going to get hurt. Your Honors, he knew that the bystander in this case, Miss Wangari, was between him and Mr. Grange. So when any reasonable person in the defendant's shoes would know that if he threw that ninja star, Miss Wangari was in his line of attack, and she could have been injured as well. Your Honors, that's all the state needs to prove to show that he acted knowingly, that he probably knew that his conduct would cause a certain result. Now, Your Honor, we go to the doctrine.
Excuse me. You just said knowingly, and then you said probably in the same sentence. Are those related, and does probably doing something knowingly what you're trying to say, or does that diminish the level of intent?
Well, Your Honor, the reason I mentioned probably is because that's the language derived directly from the statute. In fact, to act knowingly is when the person knows that their conduct will probably cause a certain result or will probably be of a certain nature. And to look at whether or not that applies to Mr. Bonaparte, we have to look at his knowledge and experience using those weapons. Like I said earlier, if he knew that those weapons could get lodged into the side of a tree trunk, he knew that those could inflict pain upon a human because they could certainly penetrate human flesh, Your Honors.
Why do we transfer that intent because I don't disagree that he knew that the knife or the throwing star could injure someone. And I think that was his intent, was to injure Mr. Grange in order to protect himself. So how do we transfer that intent for liability when it actually injured Miss Wangari versus not transferring the intent of self-defense?
Well, Your Honor, while on paper it might seem that transferring the intent of self-defense is a sound legal policy, applying it is a troublesome problem. See, the doctrine of transferred intent, as Your Honors noted earlier, is to make sure that criminals are held liable even if they might have bad aim or hit the wrong person. We don't want criminals to go unanswered for their actions. But trying to transfer self-defense is setting a dangerous legal precedent. Your Honors, the petitioner's claim is that as long as someone can prove to a court of law that they reasonably believe they were in imminent danger, they could throw a weapon and hurt anyone but they can't be held liable for that
What about the
assault.
policy of not turning a victim into a criminal? It seems like that's what transferred intent would be doing here if we do what the petitioner suggests.
Well, Your Honor, in that case, we need to look at how a reasonably objective person would act in the defendant's shoes, and not just what the defendant subjectively believed. Your Honors, just because the defendant...
If you could pause on that for a moment, is there both a subjective and an objective component to the self-defense, or one or the other? If you could put the framework around that first before you go into your answer.
Well, one of the prongs of self-defense looks at a bona fide belief of imminent danger that was laid out in the case of State of Ohio versus Philip Palmer. And to clarify the answer to your question, Your Honor, in the case of State versus Teresa Thomas, the court held that imminent danger applies if a defendant both reasonably and honestly believes that they are in harm's way. This suggests that a reasonable standard can't just be determined just off of the defendant's subjective beliefs, but also what an objectively reasonable person would believe in that scenario. Your Honors, while the defendant may claim to have been in imminent danger during this scenario, the fact of the matter is the insults, the kicking of the rugby ball, and the fact that Mr. Grange held a knife up in the air, they don't constitute imminent danger, as there was no indication that that knife was going to be thrown at the defendant.
Let's say we disagree with that. Can you still win?
Could you be more specific as to what you mean by disagree with that?
Yeah. Let's say that we think that had Mr. Bonaparte thrown the throwing star and hit Franklin Grange, that it would have been a justified act of self-defense. Let's say that's what we think. Now, of course, the fact of the matter is that he hit Tina Wangari.
Right.
So, do you have a path forward if we think that his act, had it been accurately directed, would have been an act of self-defense? Do you have a path forward to sustain the conviction in light of the fact that it hit Tina Wangari?
Well, Your Honor, it doesn't necessarily matter who was ultimately hit, because it's our contention that there was no imminent danger to be derived from the situation in the first place.
Counsel, we're saying...
Yeah, I hear that, but assume that we disagree with that.
Okay.
Is that case over for the state, or do you have a way to move forward?
Well, Your Honor, the piece of case law that I can direct your attention back to, State versus Thomas, we emphasize objectively how someone would act. And to your point, Your Honors, even if the court of law might disagree subjectively, the court still needs to consider objectively how a reasonable person would act in the defendant's shoes.
What I think we're saying is, say that I think that it was self-defense was justified, period. Self-defense justified. Do you still win because the victim was Miss Wangari and it wasn't the aggressor?
Well, yes, Your Honor, because we do not transfer self-defense, the intent to commit self-defense, the same way that we transfer criminal liability, as was mentioned earlier.
And I think that's where I'm also having a problem, because you're telling me that if I'm being attacked and there's a group of other people there, my choice is to either protect myself and potentially go to jail for erroneously hitting someone else with a firearm or other projectile, or be killed myself. And that seems to be a very difficult proposition to adopt.
Well, we understand the question, Your Honor. So essentially what the state is arguing is that in order to transfer self-defense, this is a very rare piece of action that a court must take. And very rarely have courts ever granted this motion. Your Honors, in order for that to even be a consideration, we need to look at what the trial court's jury actually ruled. Now, in a case cited in the case law of State versus Howard, the First District Court of Appeals reversed a defendant's manslaughter conviction, specifically because they felt that the trial jury's failure to instruct the jury on transferred self-defense negatively affected his conviction. Now, specifically, the trial jury found that the defendant in that case did act in self-defense against the threat, but again, he missed the intended target and hit an innocent bystander. So even because the jury found that the defendant correctly conducted self-defense against the intended victim, the appeals court then reversed that decision, saying that because he acted in self-defense against the intended victim, it would be proper to transfer that to the unintended victim. But looking to the results of the trial court in today's case, that's not what they held. The jury rejected the defendant's claim of self-defense against Grange, so there is no logical transferring of intent to self-defense as it relates to Ms. Wangari. Now, Your Honors, directing your attention to the case of State versus Reese, it held
Do we know why the jury reached the conclusion it did? There was a self-defense instruction. So do we know whether it was a matter of transferring of intent or just a matter of not believing self-defense was justified as to Grange?
Well, Your Honor, the stipulated facts of the case tell both parties that the trial jury was instructed on all statutes for assault, including the felonious assault and all lesser statutes, including what it means to act in self-defense and presumption of innocence. Therefore, because the jury rejected the defendant's claim of self-defense against Mr. Grange, it would be erroneous to transfer any self-defense to Ms. Wangari, because there is no self-defense to transfer.
Well, except, was the defendant charged with felonious assault on Franklin Grange, or was he only charged with it as to Ms. Wangari?
Well, he was charged with felonious assault as to Ms. Wangari, but the trial court looked at the issue of whether or not the defendant was even acting in self-defense against the intended victim, because that is the argument that defense counsel brought up in the original trial.
Well, so in other words, he could have been convicted because the jury didn't believe he acted in self-defense at all, or he could have been convicted because the jury didn't believe he acted in self-defense as to Tina Wangari, who was not, after all, a threat to him.
Well, once again, Your Honors, the jury was instructed on what it means for someone to be acting in self-defense, and as they rejected this to Mr.
Which
Green.
of those theories, I mean, we're now at a second layer of review. Didn't the judgment you were defending below the majority of two judges, didn't they accept the idea that the defense was as to Ms. Wangari? You can correct me if I'm wrong, but I think that's the way that opinion plays out.
Could you rephrase the question, Your Honor?
Yeah, I'm just wondering, you're bringing us back to what the jury may have thought, but we have an appellate opinion below. So are you defending the reasoning of the two judges that supported the judgment you're supporting?
Well, Your Honor, we look not only to the majority opinion, but also as to the petitioner's point. When we talk about transferring self-defense, it's highly crucial that we look at the original outcome of the trial court. Because, once again, the majority opinion was only written after the defendant appealed the conviction of the trial court to the intermediate appellate court. So, Your Honors, we defend not only the judge's opinions, but we look at how the jury rejected the defendant's claim of self-defense. In summary, Your Honors, because the defendant acted knowingly and knew the outcome that his conduct could hurt someone, he was not in any imminent danger during this assault, and self-defense cannot be transferred. He is guilty of felonious assault beyond a reasonable doubt. The defendant knew the risks of playing with fire. For these reasons, we ask that you affirm the defendant's conviction. Thank you.
Thank you. Petitioner, you have something more?
Yes, please.
2 minutes.
Firstly, Your Honors, the prosecution has laid out that Bonaparte was acting recklessly in throwing a ninja star into the crowd, and negligently in that Grange wasn't looking at him when he cocked back the knife. If this is the case, then at most, Ty should have been convicted of lesser crimes such as negligent assault and regular assault. But that doesn't matter because I'm here to tell you why he shouldn't be convicted at all. The prosecution dwelled a lot on the bona fide belief part of it. And again, to stress the fact that it wasn't just a kick. There was a threat because Tiberius knows that the knife is for throwing. It doesn't matter if he is standing over him because of that fact that it is a throwing knife. He could be a few feet back, he could be standing over him. He can throw that knife from whatever distance. Additionally, the probable outcome from Tiberius, as the prosecution said, was knowingly going to hit a crowd, but that's not the case. Tiberius was trying to harm Grange, acting in self-defense, and because of this, if he would have hit Grange, he would have been acting in self-defense. And as we talked a lot earlier, and as I have proved, it is necessary that this court establishes new precedent for self-defense transfers. Again, Your Honors, he had the bona fide belief. He didn't start the situation, and duty to retreat does not matter in this case. That's all for me, Your Honors. Thank you.
Thank you. The case is submitted, and thank you all for your presentations. We will now deliberate. Thank you. Standing before a panel such as this one is not an easy thing to do. And you all presented well and did not get flustered or overwhelmed or any of those kinds of things. So I think that was great. Beyond that, I think that petitioners, you were well organized, that you knew what you wanted to say. I'm not sure that everything came out quite as clearly as you would have liked, but I think you did a nice presentation. Respondents, I think that your presentation was good, very well organized. I think that your side of the case was a little bit easier to argue, and yet, I again didn't get flustered or frustrated or lose your place or any of those kinds of things. I think you did a nice job.
Start with me? Okay. Yeah, thanks for doing this. Like it brings a lot of joy to me given what I do, and being part of this from the very beginning. Years ago, you were probably in kindergarten or something. I shudder to think where you were when we first thought about this. You both had a really nice command of the lectern. That can be a tough thing to do when you're under fire from people like this. You both had kept control of your pace and kind of showed us where you were headed. It's an important thing. I mean, you'll hear there's only one real judge up here on this panel, but the ones that I've talked to, in addition to the former justice here, that can be one of their biggest frustrations, is not having a sense of where you're going and the organization of what you're trying to present. I thought you both did a very nice job of that. Just a couple of comments for each side. So on the petitioner side, they had a really nice grasp of the mental states. That's a tough thing, especially if you're still in high school. That's the thing that still bedevils some prosecutors and defense attorneys. There's a significant case pending in the Ohio Supreme Court, or maybe pending soon, on that very topic. It's a tough one. I thought you did a good job also of not over-claiming on the case law. Some of our questions pushed you a bit on, like, does the case law say this? Can you give me support for that? And not over-claiming what was inside those cases that you had to read. I did think, now I'm going to switch over to some constructive criticism, and take this with a huge pile of salt. Like the people I am normally giving feedback to are folks that appear in the U.S. Supreme Court, the Ohio Supreme Court, et cetera. I'm not in high school. I thought when it may have been me, someone else asked you a question about other paths to victory. I thought maybe you could have used the dissent here and the burden of proof. They're both in your favor there to a little more effect. And then I did really like the conclusion. It's nice to exit the entire presentation with both in your opening speech and the end, instead of to have something that structures the relief you want. It was a little bit on the long side for what you typically see, but I did appreciate that. Thank you. Okay. Respondent side. They made a very good use of the statutes and the case law as well. You had a good command of that. I thought you had a nice answer to the Chief Justice's question about probably you really knew that, look, those are not two different words, like the difference between knowledge and recklessness. You knew the statute used that to define the relevant mental state here. Some constructive thoughts. I thought on the facts, maybe, and this is hard in a canned factual situation, you're not operating under the normal standards for a jury trial here, and the artificiality of that is difficult, I think, for all of us who are practicing lawyers. So take that as you will with this. But I thought on the facts, maybe you were reading more into them than what is warranted by what you're kind of hemmed into here. And then I guess the other thing I would say is, at the very end, I again liked your conclusion. It seemed like maybe you could have picked of the two different paths, emphasize which of those you sort of preferred, the different paths to getting to an affirmance here. So that I thought let the conclusion lose a little bit of its focus they might have otherwise had. So, but excellent. I mean, really, really excellent work for folks who are in high school. I appreciate the chance to be here and to hear folks like you that are the future. That's all I've got.
I can echo all of that. I was incredibly impressed by just your presence for being in high school and this being a competition. There's nerves. You wouldn't be able to tell. You had quite a bit of confidence and quite a bit of gravitas, both of you, and you have different styles, but they both came across very authentically. So you're excellent advocates. I feel like your command of the case law and drawing on it to answer questions was really strong. You knew things just off the top of your head, this mental states. I'll echo the one piece of constructive criticism is the facts. I feel like there was a little bit, both of you I think said, I assume, we can assume, and we really can't. And I think even the dissent, sort of called that out, that was really your burden of proof. And so just being careful, because you were so strong on the case law that was there in the statutes, to just also be strong on facts when you're arguing cases like this. But really, really impressive job by both of you.
Yeah, I echo that, that your command of the facts and the case law, well, the case law particularly, was really good. And I echo all the positives that have been provided, and I won't rehash them. As a constructive, I would say pay attention to the question asked. Now, you're not going to always agree with the question. You're not always going to agree with the way the judge is going. Sometimes they're showing their hand. Sometimes they're just trying to figure out the constraints of what you're asking for. I mean, we're pretending to be a Supreme Court, so it would be new law that we're asking. So we're trying to figure out what are the parameters of this new doctrine that's maybe being proposed to us. And so it might test those boundaries. And so you got to be able to answer the question and then pivot back to what you want to talk about, instead of just kind of not answering and then moving on to that question. And just as an aside, hypotheticals can be crazy. I was in an argument, and one of the justices, I don't know if it was me or my opposing counsel, the hypothetical involved a centaur. So, I mean, they can be absolutely crazy, but you still have to answer them. But good job. You should be very proud of yourselves, and I'm sure your advisors and your family are.
So, little enough that I can add after 4 such excellent critiques, except to say that splendid work, all of you. And I hope you don't find it patronizing for me to say that I'm proud of you and everyone who's been in this competition. I think it's fair to say that our world is changing, and we need people like you who are informed citizens, who can distinguish fact from fiction, who are critical thinkers. And if my long involvement with this program entitles me to ask anything of you, it would be this: don't stop. Keep reading, keep thinking critically, keep participating. We need you.
Thank you.
Thank you all.
You'll stay. Yes. Congratulations. We will now retire our judges from the bench. All rise. You may be seated. Congratulations again on competing in the 2025 Moot Court State Competition. When I saw you guys did an amazing job, and you should be incredibly proud of yourselves. Moot Court is a very rigorous program, so all of you who participated should be incredibly proud of yourselves for what you have achieved. Next, I'd like to thank several people and groups for making this competition possible. First, thank you to our teachers and advisors. Your guidance and support are invaluable to your students' success here today. Thank you to the volunteers who judged today or evaluated briefs. We could not do this without you. Thank you to the Ohio Channel for filming our championship round. And finally, thank you to the OCLRE sponsors the Supreme Court of Ohio, the Ohio Attorney General's Office, the Ohio State Bar Association, the ACLU of Ohio Foundation. In addition, thank you to the Ohio State Bar Foundation for their financial support of the program. With that, we have several teams and individual students to recognize for their achievements in the Moot Court program. First, I want to acknowledge all 4 semifinalist teams and their students. So congratulations again to Danville High School, St. Ignatius High School, Mason High School, and Springfield High School. Finally, we have 2 incredibly talented teams and students before us today in the championship round, both of which deserve our full acknowledgement. We have St. Ignatius High School Team 1, which includes Alexander Ament, Patrick Einloth, Ethan Montaigne, Ethan Rosa, and Luca DiGeronimo. Also, in the final round is Mason High School Team 1, which includes Santosh Rajan, Aditi Garakapati, Aaron Sharma, Aprana Nair, Sujan Mohana Sundrama, Mia Meenakshi, and Haley Klinker. Congratulations to both teams on your hard work, preparation, and performance. Now it is time to announce the competition winner. The 2025 Moot Court State Champion is Mason High School. And again, due recognition and congratulations to our 2025 Moot Court State runner-up, St. Ignatius High School.
Thank you.
Congratulations again, everyone. Have a wonderful evening and safe travels back home. We hope to see you back here in 2026.